Hi, I'm Michael Hughes, and this is Contract Mastery.
Paragraph 6 of the 1 to 4 family contract deals with the title policy and the survey. Paragraph 6 it's just a beast. It is the longest paragraph in the 1 to 4 contract. It stretches out onto 3 different pages of the contract form, and it covers a lot of ground. That's very important. But we're going to take it step by step, piece by piece, and then try to fit it all together at the end. So don't worry about the size of it or that it's overwhelming. Let's just take it paragraph at a time. We're going to start with paragraph 6A that deals with the title policy. And before we dive into the contract terms, let's have a look first at the big question. What is title insurance and why do we need it? You're going to get asked that a lot particularly by buyers. So, title insurance, it is an insurance policy. It is designed to protect the owner of the property or the lender against claims by others of ownership to the property, or if others claim some sort of an interest in the property. You can compare title insurance to other forms of insurance, let's say auto insurance. With auto insurance, you buy the policy today and it protects you going forward against things that may happen in the future, right? Car crashes, things like that. Title policy, on the other hand, you buy the title insurance, you pay for it one time at the closing, and it protects the owner or the lender looking backwards against things that may have happened in the past. The title insurance company is going to research the chain of title of the property every time that property has changed ownership. And they're going to look back as far as they can find records. They're going to look for things that might indicate a defect in the title that's being transferred to the buyer or that the lender is wanting to use as collateral for the loan. Once the title company is satisfied that there are no defects, that there's a clean chain of title, it will issue an insurance policy to guarantee that there are no defects in the title. But like any other insurance policy, the scope of coverage of a title insurance policy is very carefully defined by the title insurance company. There are exceptions to coverage. There are limitations to title coverage that are applicable to the property and that we need to be aware of so that we can answer questions for our clients or to understand when it's time to refer them to the title agent for more in-depth questions. There are two basic types of title insurance policies out there in the world. One of them is an owner title policy, and it protects the owner of the property, which means the buyer in a real estate contract. And then there's a lender title policy, and that policy protects the lender. The coverage under a lender policy is up to the outstanding principal amount of the mortgage loan. So as the owner is paying down their mortgage with each monthly payment, the total amount of coverage under the lender's policy is reduced by the amount of the principal that gets paid off with each mortgage payment. A couple of points to remember in general about title insurance policies. One, it is always the seller who furnishes the title policy to the buyer. It's always the seller providing the policy. Now, who's going to pay for the policy? Well, that's negotiable. Which title company to use? That's negotiable. The policy always has to be in the amount of the sale price, and the policy must be dated at or after the closing date. Let's take a look at what 6A says. The seller shall furnish to buyer at either the seller's or the buyer's expense an owner policy of title insurance issued by, and here we're going to insert the name of the title company that's going to issue the policy, in the amount of the sales price that is dated at or after the closing, that insures the buyer against loss under the provisions of the title policy, subject to the promulgated exclusions, except for existing building and zoning ordinances, and subject to the following exceptions. And then there's a list of 9 exceptions, things that are not covered under a standard title insurance policy. These 9 items include restrictive covenants. So the title insurance company cannot issue an insurance policy that protects the owner against restrictive covenants, obviously. There are standard printed exceptions for standby fees, taxes, and assessments that are applicable to the property. We can't put in a title insurance claim because we have to pay property taxes. That doesn't work. An exception against liens that are created as part of the financing described in paragraph 3. When the lender issues the loan, of course, they're going to take a security interest in the property. We call that a mortgage. It's embodied in a document called a deed of trust. But we cannot use the title insurance policy to get around that lien. Does not protect against utility easements, does not protect against reservations or exceptions that are otherwise permitted by this contract or that may be approved by the buyer in writing. So if the seller reserves, let's say, some sort of mineral interest or an easement, that's going to be an exception to coverage under the title policy. There is a standard printed exception as to marital rights because Texas is a community property state. And there is a standard printed exception as to waters, tidelands, beaches, streams, and related matters of that nature. Those are not covered under the title policy. I'm going to skip number 8 for right now. We're going to come back to it, but let's look at number 9. There is an exception or an exclusion regarding minerals that has been approved by the Texas Department of Insurance. We don't talk about the details of what that exception says in the contract. It will be in the title commitment, which we'll talk about in a bit, but we are letting the buyer know that these are the exceptions to title policy coverage. Number 8, another exception to title policy coverage is the standard printed exception as to discrepancies, conflicts, shortages in area or boundary lines, encroachments or protrusions, or overlapping improvements. These are all items having to deal with either the survey or the boundary lines, the property lines. These things typically are not covered under a standard title insurance policy. Now, the parties to this contract have a choice. They can either leave that standard printed exception alone. It will not be amended. It will not be deleted from the title policy. Or the parties can choose to amend that exception, number 8. And if they amend it, it will read only that the exception is for shortages in area at the expense of the buyer or seller. This one causes some confusion, so let's look at it a little more closely. The standard printed exception for number 8, these are the things that normally the default case, these are not covered. Discrepancies, conflicts, shortages in area or boundary line, so having to do with the property line of the property. encroachments or protrusions onto the property, or overlapping improvements. All those things are not covered under a standard title policy. But if the parties choose to amend the printed exception, then we eliminate some of the exceptions. And then the only thing that is not covered would be shortages in area. If there is a survey discrepancy and there's a shortage in area, if we amend that exception, then shortages in area is the only thing that is not covered. So as a result of this, the buyer is going to get more extensive title coverage if we choose to amend that exception. And because the amended exception is going to provide more title policy coverage for the buyer, the title insurance company is going to charge an increased fee for that additional coverage. And in that case, that is where the parties get to choose who is going to pay the additional charges, either the buyer or the seller. In a standard subdivision lot, this really is not such a big issue at all because the subdivision lots are pretty well defined. And unless someone has, I don't know, poured a concrete slab that's sticking over onto their neighbor's land, you're not really going to have issues or boundary disputes normally. So, not such a big deal in an urban subdivision type setting. But if you're dealing with a large rural tract of land and a survey discrepancy of maybe 1 degree as we're trying to plot out boundary lines, well, as you go along a large, long boundary line, that little discrepancy can spread out and suddenly become a big chunk of land. So normally you're more likely to see an issue over this exception number 8 when you're dealing with a large plot of land or something in a rural area where it's not platted and it's not been, very precisely mapped out. In most cases, the name of the title company in paragraph 6A is going to be the same title company that the parties are going to put in paragraph 5A. Normally, it's the same title company that acts as an escrow agent as the one that's actually issuing the title policy. But it doesn't always have to be that way. There are fee attorneys, they're called, and they operate small offices. They're sponsored by title companies. And so it may be that in those cases, the fee attorney's office may be acting as your escrow agent. But the title policy itself is going to be issued by the title company that is sponsoring that fee attorney's office. So that's one instance where you may see the names different in paragraphs 5A and 6A. But most of the time, they're going to be the same. So the next question that comes up is, who picks the title company? Which party gets to choose the title company? And man, oh man, if you want to see 2 grown adults devolve down into screaming children, then let 2 realtors get into an argument over who's going to choose the title company. It's real interesting to watch, right? The choice of the title company is actually addressed in RESPA. RESPA Section 9 discusses the selection of the title company, and here's what RESPA has to say. If the seller is paying for the owner's title policy and the lender's title policy, then the seller gets to choose the title company, no questions asked. On the other hand, if the buyer is paying for the owner's title policy, then the buyer gets to choose, and the seller cannot condition the sale of the property on the choice of a particular title company by the buyer. So if seller's paying for owner's policy and lender's policy, seller gets to choose. If the buyer is going to pay for the owner's title policy, then the buyer gets to choose. But unfortunately, these are not the typical scenario in a Texas real estate transaction. Normally, the most common thing that we see is that the seller agrees to pay for the owner's title policy and the buyer agrees to pay for the lender title policy. And in that situation, RESPA does not give us any clear answer. There has been at least one court that has held that in cases where the seller pays the title policy and they did not condition the sale on the selection of that title company, then there was no RESPA violation when the seller insisted on a particular title company. Okay, but the federal agency that enforces RESPA is the Consumer Financial Protection Bureau, and they have not taken an official position on this particular question. So for us, the best practice, and is also the safest until we get some clear guidance from the CFPB, is for the seller, don't insist too heavily on a particular title company unless your seller is willing to pay for both the owner policy and the lender policy. In that case, it's very clear that the seller gets to choose. So, what are some best practices when we're talking about choosing the title company? Well, the listing agent can open title as soon as she takes the listing. As soon as you get a signed listing agreement, you can send that listing agreement to your preferred title company, ask them to open title, and they will. And then you can say in agent remarks on the listing, hey, title is already open on this property. Contact the listing agent for details. Do not put the name of the title company in the MLS listing because of wire fraud concerns, but you can tell them that title is already open. Contact me for details. You can talk up the strengths on either side of your preferred title company. You can talk about the great experiences you've had. You can talk about what great service they provide and try to convince the other side, okay, we'll go with your preferred title company. But at the end of the day, sometimes the buyer, particularly the buyer's agent, sometimes you just have to choose your battles. At the point where we're deciding on the title company, we have not even had an inspection. We don't know anything about what sort of repair negotiations may be needed to get this file past the option period. And in most cases, in my opinion, it is best not to burn up your credibility or your negotiating capital with the other side on an argument over the title company. Unless it's a title company that you've used before and it was just a horrible experience. And then talk to the other side about it as professionals and say, look, I had this happen in this other experience. Can we please not use this title? Let's use somebody else. On the other hand, if the listing agent already has title open at a particular title company, it's not very likely you're going to convince them to change. If your buyer wants to step up and say, okay, I'll pay for the owner title policy, fine. Well, then the buyer gets to choose. And if they have to move title from one company to another, so be it. So my advice here is choose your battles. It is usually not worth it to get very confrontational and combative at the very outset of the transaction over the choice of title company. Save your credibility for the repair negotiations where it's really going to be needed more. Well, let's look at paragraph 6B, the title commitment. What is this thing? The agent typically gets a copy of it from the title company, and you do absolutely need to review it and go over it with your buyers. But what is it? Well, the title commitment is the title company's promise that they will issue a title insurance policy at or after the closing with the same coverages and exceptions as are stated in the commitment. We promise we will issue a title policy along these lines as are outlined in this written title commitment. It will include all of the exceptions to coverage. It will include any completion items that need to be done. Hey, there's a lien on the property that we're going to have to get cleared. It'll all come out in the title commitment. That's why it's critically important for agents to understand how to read a title commitment and to make sure that you do it each and every time that you have a transaction and be able to go over it with your buyer, even if it's just to say, oh, title commitment looks great. We have no issues. Do you have any questions about it? And then you'll be able to answer their questions. The more information you're able to convey to your buyer about this sort of thing and others in the transaction, the better you look. And the more confident the buyers are that they truly do have a real estate expert in their corner. The title commitment, like we said, is also going to have conditions that have to be met before the title company will issue the title policy. So if there are documents that need to be obtained, if there are lien releases that the seller's going to have to get, all those types of things, it'll all be listed in the title commitment. Well, let's look at what the contract has to say about the title commitment. And bearing in mind also that the title company is not a party to the 1-to-4 contract. This is the buyer and the seller making agreements among themselves as to what the title company is going to do. So 6B says, within 20 days after the title company receives a copy of the contract, not the effective date, but 20 days after the title company receives a copy of the contract, the seller shall furnish to buyer a commitment for title insurance and, at the buyer's expense, legible copies of restrictive covenants and documents evidencing exceptions in the title commitment. We call those exception documents, other than the standard printed exceptions that we've already gone over in paragraph 6A. So these items have to be delivered within 20 days after the title company receives a copy of the contract. The copies of the restrictive covenants and the rest of the exception documents, the title company will get from either the county clerk's office or the HOA or combination of them. And this will be a buyer's expense. The seller authorizes the title company to deliver the commitment and the exception documents to the buyer at the buyer's address as shown in paragraph 21. Paragraph 21 is the paragraph that deals with notices under the 1-to-4 contract. We will come back to that in just a minute. If the commitment and the exception documents are not delivered to the buyer within that specified time of 20 days after the title company receives the contract, then the time for delivery is automatically extended up to 15 days or 3 days before the closing, whichever one happens first. And then if the commitment and the exception documents still are not delivered within that extended time period, in that case, the buyer has the right to terminate the contract and receive back the earnest money. So for the title commitment, the title company has an initial 20 days to deliver the commitment. If they don't deliver the commitment within that 20-day period, they get an automatic extension of either 15 more days or up to 3 days before the closing, whichever one happens sooner. If the title company still has not delivered the commitment and the exception documents after that time, then the buyer has the right to terminate and get back the earnest money. The reason that we have on our receipt page for the 1-to-4 contract a separate block where the title company signs to acknowledge receipt of the contract is because of this requirement right here, to provide the title commitment to the buyer within 20 days after the title company receives the contract. That's the reason why we have the title company sign a receipt saying, I have received the contract as of this day. And once again, remember, the title company is not a party to the 1-to-4 contract, and they do not agree to do or not to do anything under the 1-to-4 contract. So even if you come across a title company that is just grossly negligent and they don't provide the title commitment and it's simply because they've just dropped the ball, the buyer doesn't have any recourse against the title company. The only thing they can do is what is written in the contract, and that would be terminate and get their earnest money back. So what is required to be delivered with the title commitment? We just went over this in the language of the contract, but let's look at it again. The items that have to be delivered are the title commitment, that is the title company's promise to issue the title policy, and also the exception documents. And when we say exception documents, we mean legible copies of the restrictive covenants and any documents evidencing exceptions to coverage in the title commitment. The exception documents the contract requires are required to be furnished to the buyer, but the buyer has to pay for them. If there is a fee for obtaining copies of those documents, that is a buyer expense. The seller is going to authorize the title company to deliver those documents, the commitment and the exception documents, to the buyer at the buyer's address as shown in paragraph 21, which pertains to notices. Here is another reason. We're going to talk a lot more in detail about this when we get to paragraph 21. But spoiler alert, agents, particularly buyer's agents, you always want to have in paragraph 21 at least an email address for your buyer so that things like the title commitment can be sent to your buyer directly. What happens if the commitment is not delivered on time? We've talked about this, but once again, if they are not delivered within the 20 days after the title company receives the contract, then the time for delivery is automatically extended, either 15 days in addition to the 20, or if we're coming up on the closing date, then the deadline is 3 days before the closing date. Whichever one of those happens sooner is the extended deadline for delivery of the commitment and the exception documents. If at the end of that extended time, the title company still has not delivered both the commitment and all of the exception documents, then the buyer has the right to terminate and get back the earnest money.